Any mention? Item number 1.
Yes.
Please, Your Lordships. Lordships, I beg to pray for some time to file a rejoinder to the affidavit which was filed by respondent 14.
Last year it came for what?
Orders only, my lord.
Then you're supposed for rejoinder when?
I'm praying for some further time, Lordship, because they have enclosed a lot of CDs and lots of recordings and all, Lordship. We have to...
Where? In the
affidavit,
My lord,
Lordship.
yes. He has given a compact disc, my lord.
With CDs and also I'm praying for some...
Who's
And
appearing for the...
he's appearing in...
petitioner?
I'm appearing with the petitioner.
Who's appearing for number 14? Yes.
My lord, I am appearing in person.
Yes, I remember, yes. So we'll give them some more time.
Yes, my lordship, I don't have any issues regarding giving them some opportunity for filing a rejoinder, but it's a humble request that the NLA Mr. Samuel Sharma, against whom the allegations are there, the affidavit may also be made required party in this.
File an application for that, Lordship, if you want to.
They have to find. Let's get for rejoinder on board first. Mr. S. Deb praise funds allowed further 2 weeks time to file rejoinder to the affidavit filed by respondent number 14. List accordingly and so on. So
much appreciated.
Please file it before the next date.
Absolutely.
2.
Because we've segregated this matter, so we'll take it.
We'll file it, Lordship.
Item number
2
2.
is also connected, Lordship. Maybe.
Together.
Obliged.
Yes.
Item number 3. Hearing.
Any mentioning is there?
Who's the state? Mr. R. Gurung.
Mr. R. Gurung, I think he is there.
Where is he? Now, Mr. Mahanta, last time you said that you have to ascertain whether this mild intellectual disability will be an impediment, was an impediment to the trial or whatever.
Yes.
So what are your, you said you do some research.
From my things, I feel that there's a permanent disability. Mild intellectual disability is not curable.
So you mean he cannot comprehend the gravity of his actions?
No, cannot. That capacity is not there.
Now, where's Mr. Gurung?
Maybe the Lordship is on his leg. He's coming. Now I inform him to come.
Have we done some research to ascertain a correct picture?
Lordship, I have not done anything.
Where is he?
He's in other court, Your Lordship.
You're appearing with him, correct? In this matter?
Your Lordship, last date also I appeared with him, but file is not with me, so I cannot do anything.
No, you're supposed to see, you've seen the last order. Now, Mr. Manta says that this mild intellectual disability was an impediment to him, in a trial.
It relates to unsoundness of mind.
No, mild intellectual disability doesn't mean unsoundness. Unsoundness is...
yes, it's relates to. And it's not curable.
Have you got any medical...
Yes, that's right. So it's not curable, Your Lordship. Therefore,
what
I
is
have...
the definition of mild intellectual disability? Now, what is the medical... I mean, what does it mean? Like, what is the... You mean the capacity, the mental faculties, the capacity of the...
That's what happened. They adapt to one situation only that they will do. So he's a cultivator, he will go and cultivate only that.
He'll go and...
Apart from that, he doesn't know any other thing. If he does something also, he cannot recollect, cannot remember. That type of attitude.
So the Gurung,
My lord.
how's the research?
Yes, my lord.
Just
Waiting for you.
My lord.
But because Mr. Manta said that this mild intellectual disability was an impediment to in the trial.
My lord.
That he could not have stood trial, to
My lord,
effectively defend himself.
Firstly, my lord, during the trial, my lord, this point was never raised. And that apart, my lord, there is a report saying that during the entire trial and also during the custody, my lord, there was no complaint as such, my lord. It was normal. That report is there, my lord. That apart, my lord, look at the conduct of the appellant herein, my lord. The conduct during the trial, my lord. Look at his statement in 313, my lord. He is absolutely, my lord, a normal person, my lord. He is trying to duck the questions. He is manipulating the answers. That apart, my lord, when during the appeal for the first time, my lord, the ground of insanity is claimed, my lord, the appellant has to come up with, my lord, strong documents to ask, my lord, that apart, that was nothing was brought on record. 7 except, my lord, a hearsay statement saying that a brother saying that at one point of time during his childhood, my lord, he was in the habit of eating twigs, this, that. Is that? This is nothing, my lord. At the appellate stage, this is a desperate attempt to, my lord, curtail the, my lord, the proceeding of the court, my lord.
See, Mr. Thapa, but this is the expert medical.
Mild, my lord. I'm coming to that,
hospital that he is appellant has mild intellectual.
Mild.
So we want to know what is mild intellectual disability.
Exactly,
We're
my
not
lord.
doctors here.
I'm coming to that,
my lord. Scientific, definition of mild.
My lord, there is a system of ascertaining, my lord, the psychological, my lord, competency of a person. That is done in the Raster scale. I'm coming to that. And my lord, anyone, that is, my lord, typically in common language, my lord, is IQ. The IQ of a person, my lord. So IQ of a person varies, my lord, from person to person. Now, the appellant herein, my lord, the case put forward is an illiterate person, a rustic village person, my lord. So definitely, my lord, the IQ won't be that high, my lord. In his case, it is calculated at 67. Now, what is that IQ? How it is being calculated, my lord? Ascertain. Firstly, a puzzle is given, my lord. The arrangement of puzzles, my lord, small pieces. That apart, the daily social life, rearing of the children, education of the children, whether he goes to the, my lord, his daily work regularly and he's doing it properly, his interaction with the society, that is the second. Now third is about GK, my lord, the common thing that is happening in the world in and around, my lord, whether he is aware of that. Those are the, my lord. First, my thing, there is a distinction between insanity in law and insanity as per medical, my lord.
Yes.
Those are, my lord, completely two different things, my lord. But however, time and again, my lord, the apex court as well as the high courts of India, my lord, they had been heavily relying on the medical side, my lord. Medical side. So, my lord, IQ of 67. Now, I have got a judgment here, my lord, which says that when a person, my lord, takes the plea of insanity during the appellate stage, my lord, that has to be looked into with a very strong suspicion, my lord.
Exactly, that's why you're not accepting the...
Exactly.
Even though psychological test was conducted again at the direction of the court. Now, mild intellectual disability, because, see, we are laymen when it comes to this kind of definition.
Exactly,
we don't want to do injustice to anybody.
My lord.
Suppose this mild intellectual disability has affected his faculties, affected his capacity to reason.
My lord.
That's the only thing.
My lord. Now, my lord, when insanity, IQ has come to 67, my lord,
yes,
my lord has to go through his conduct during the trial, my lord. Conduct during the trial. I'll fortify my submission with judgments, my lord. Lordship has to look into his conduct during the trial, my lord. Now, during the trial, my lord, he has never taken that plea. That apart, my lord, can you look into his, my lord, he was confronted with all the evidence that appeared to have been against him, my lord, under 313, my lord. Kindly see, he has even taken the plea of alibi, my lord. That apart, every question that is put to him, my lord, he has answered in a very, very intelligent way, my lord. Can you look into 313, my lord? So, my lord, the court, my lord, when insanity is claimed, my lord, looks into the conduct. I'm putting that judgment here, my lord.
Yes, what's the judgment?
Oh, one more copy is there. Delhi High Court judgment. This one. See? देखना. Delhi High Court judgment.
Give me a copy.
I'll give it.
Which judgment will go?
My lord, this is Division Bench of Delhi High Court, my lord.
Give citation to the senior counsel also.
My lord.
Do one thing, Mr. Gurung. Just file a small report.
My
of the
lord.
judgments.
My lord. In fact,
Then
my
we
lord.
can examine it. Then we will, because we take the preliminary thing.
my
Then we, if we find that in a considered view that yes, materials are there that he was fit to stand trial, then we'll go ahead with the regular appeal.
On merit, my lord. Even in
Instead
the.
of yes.
On merit also I have a very good case. Your
My lord, I prepared my written argument also. I'm ready with that.
No, but you have to forewarn him also.
Okay.
The judgments.
Since it
I'll share.
came
We'll
to the
exchange.
knowledge later,
We'll exchange.
Yes.
it came to us only when the jailer.
That is why we took up this matter. Actually, we were hearing it, but then since he had submitted that he has some mental disability, that's why the court said, fine, we will look.
Audio also, learned counsel said there's a medical report in the file when he was produced before the court. I checked the file, there is no such report.
My lord, that is when a person is arrested, my lord, for a cognizable offence, my lord. That is a different issue, my lord. To check injuries and in case of POXO, my lord, to collect the samples, my lord, that has nothing to do with insanity, my lord.
Okay.
Yes, pursuant to the order dated 18/3/2025, Ms. R. Guru has submitted that on the submitted that the appellant, though shown to have mild intellectual disability, the same, however, would have no effect on his capacity to stand trial, or has no effect on the trial, and that the appeal be taken up for regular hearing stuff. He further praised that to substantiate his suppression, we were allowed to file a report with regard to the medical definition or description as to mild intellectual disability, and also support the same with decisions as to this ground being taken only at the appellate stage. Yes, praise allowed. Stop. Mr. S.P. Mantala, senior counsel for the appellant, also praised that he may be allowed to bring on record some materials on this point. What praise are allowed? Praise allowed. We listed after, and we'll have list after 2 weeks for consideration on the on this preliminary issue.
Yes.
Deputy Bench.
Obliged.
You bring the materials, then we'll pass orders there. Only then we will. Yes.
Any mention?
May I please your Lordship? Lordship, I beg to mention item number 4, Lordship. In this matter, we are going to file our affidavit in opposition during the course of the day, Lordship.
For the orders, he mentioned when it's called out, okay?
Lordship, I beg to mention item number 5 also, Lordship.
You mentioned when it's called out.
Yes. Item number 8, my lord, is joint request by the appellant and the respondent, my lord. Let it come after 2 weeks, my lord.
Okay. Yes.
Hello.
Yes.
Lordship, I beg to mention item number 7 for 2 weeks, Lordship.
Who's the other side? No objection? 2 weeks, okay. Yes. Yes. What about number 1?
Item number 1.
I don't see your name on the call list.
I've already signed the Vakalata, my lords. For some reason, it's not reflecting.
Yes.
This is an appeal under section 260A of the Income Tax Act, sealing an order dated 25/10/24, passed by the Income Tax Appellate Tribunal at Guwahati, my lord. I'll just take your lordship very briefly to the facts of the case. As the appellant company had filed its income tax return for the assessment year 21-22, and if your lordships will have, the ITR is about 110 pages. I'll just take your lordship to the relevant portion. Page 42, if your lordships will, can you have?
Page?
42.
Who's been for income tax?
My learned
You're there. Yes.
At page 42, lordships will see, under the head, serial number 14, other income.
Yes.
Can you see Roman 7?
Yes.
It mentions profit on sale of other investment. This is about 6 crores 38 lakhs 81,925. So honestly, we had reflected this in our ITR. However, my lord, please have page 57. So this is classified as a capital gain, and the tax implication on this is very different from the tax implication on active business income. Now that was mentioned at page 57.
Yes.
Please see, it says computation of income from business or profession. This is the active business income of the company. At serial number 3, my lords will find in that box, income/receipts credited to profit and loss account. And against that, in the third column, there are several other heads: house property, capital gains, etc.
Didn't show capital
Against capital gains, my lord, I ought to have reflected this amount of 6 crore 38 lakhs, but on account of some inadvertence, my lord, on the company.
This is your return, it's filed by you.
Yes, my lord. There was an inadvertence on the part of the officials of the company. This was not reflected here. But we have otherwise disclosed it in the other portions of the ITR. So as a result of this omission, my lords, I received an intimation of the assessment from the Income Tax Department, which is at page 129.
Yes.
My lords of habit. This is dated 11/11/22. The date is mentioned in English in the bottom. There are several dates in English. ITR, then 14/2/22, then 11/11/22.
This is one page 129.
129, my lord. Annexure 5.
Okay. Yes.
So this is the date of the intimation. The relevant portion in English is at page 151. So in view of the omission on my part to mention, to make that adjustment with regard to the sale of that income, what's happened is in the assessment, this has also not been mentioned. Kindly see heads of income, serial number 3 at page 151. Income under the heads capital gain. So this is 0. So as a result of this, my lord, I was aggrieved by this.
Apart from your other business and profession.
Lordship. So I immediately filed an application for rectification.
How do you correct it?
So I filed it, my lords, at page 169. I filed an application for rectification, annexure 6.
Yes.
Please see, this is an application dated 21/11/2022. It is addressed to the Assistant Commissioner of Income Tax. May I just read the relevant portion, my lord? Dear sir, this is with reference to the return of income filed by the company for the assessment year 21-22 declaring total income of rupees so and so, it is submitted that the income tax return suffers from apparent mistake for which the present application under section 154 of the Act is being preferred before your Honour. Non-exclusion of profit on sale of investment from computation of business income. During the relevant year, the company had earned a profit of 6 crores 38 lakhs so and so from the sale of its investment, which was disclosed at serial number 14.7 of Schedule Part A. In its return of income filed on 14/2/22 for the relevant year, copy of the relevant extracts of the ITR is enclosed as Annexure 1. The said profit on sale of investment being accessible to tax under the head of income so and so, considered by the SSE while reporting the corresponding details at serial number 9 of subhead so and so of the income tax return. Copy of the relevant schedule CG of the ITR is enclosed at Annexure 2. The company, however, submits that it had erroneously omitted to reduce the profit of 6 crores 38 lakhs on sale of investment by way of deduction at serial number 3B at so and so. This inadvertent omission being a mistake apparent from record may kindly be rectified. In view of the above, we request you to kindly process this rectification application at the earliest and recompute the tax payable refundable to the SSE. So, my lords, this application for rectification is only confined to the non-exclusion of that income. At the same time, lords, I filed an appeal which is at page 171. This is a statutory appeal before the CIT appeals, Commission of Income Tax Appeals. The date is available at the bottom at the signature, my lords. 2022-12-1. So on the 1st of December I filed the appeal. Kindly see serial number 3 and 4. Yes. An intimation order under section 143(1) was sent to the company on 11th November 22, making disallowance in the return of income of rupees so and so on account of disallowance of bonus, provident fund, leave encashment and gratuity under section 43B of the Income Tax Act. Further, the TDS credit of INR so and so was disallowed. CPC erred in non-exclusion of profit on sale of investment of so and so from the computation of business income in the return of income. So this is a comprehensive appeal, including that non-exclusion. Those are my grounds of appeal at page 172.
What happened after that?
So this, my lords, was dismissed by the CIT appeals by an order at page 173.
What did he say in the
The relevant portion, my lord, is at page 178. At the bottom, my lords, para 5. Ground 1 is general in nature. In ground 2, the appellant has objected to non-exclusion of profit on sale of investment amounting to so and so from computation of income of financial year 21-22. The appellant admits that it had erroneously admitted to reduce the profit of so and so. And then kindly come to the line after that. The CPC has not made any adjustments and has accepted the ITR filed only. If the appellant has made a mistake, it has to be corrected by filing a revised return or under section 264. This is not an error apparent on record to be rectified under section 154 or to be
264, 154.
264 is a power of revision available with the CIT appeals, and revised income will have to be revised return will have to be filed before the original assessing officer. This is not an error apparent on the record to be rectified under 154 or to be considered in appeal. The CPC has not made any addition and the grievance is not against the 143(1) order or against the CPC. The ground 2 raised are not valid and are dismissed. Against this, I preferred a further appeal before the Income Tax Appellate Tribunal, my lord. That is at page 189, the order which was passed. And date of the order is 25th of October 2024. The relevant portion is at page 189.
Yes.
Para 6 onwards, my lord. So here they discuss the same thing which is there. Thereafter they reproduce the order of the CIT appeals, and please see para 7.
Yes.
We observe that the learned CIT appeals did not deny the claim of the SSE. The learned CIT appeals also did not deny that the SSE has not reduced the profit amount of rupees so and so by way of deduction. The learned CIT appeal has held that the assessee can file a revised return if he has made a mistake. In our opinion, the learned CIT appeals has correctly made his observation. It is not the case of the assessee that he has filed revised return and the same is rejected by the revenue. Why not the assessee filed revised return so as to correct his mistake? Therefore, the issue we hold against the assessee. However, we direct the learned CPC AO/CIT appeals to consider the revised return if filed by the SSE on this issue. We are just concerned with this last line, my lords. Please see, the ITAT directs us to go before the CPC AO, that is the Centralized Processing Center Assessing Officer/CIT appeals. My lords, we don't wish to go for the CIT appeals.
Why?
That would mean we would lose a forum, my lords. This is the appellate forum. We are content with going before the CPC, that's the assessing officer. But the only problem we are facing now is that the website is not giving us the option of filing a revised return.
What does your prayer say?
My prayer was, my lord, to set aside this order because we are under the impression that the appellate authority itself could have allowed this entire deduction.
Yes, Mr. Pandey.
Lordship,
It's not such a enormous issue. It's a very
Lordship,
small
it's a very limited issue,
question
Lordship.
of division, yes.
Lordship, I prefer
very
to
minor order can be passed, my lord. Just a minor modification to this last line that we may be permitted to approach.
Lordship, I prefer 2 weeks time, Lord. I'll obtain
Lordship. Heard Mr. S. L. Leonard's counsel for the petitioner. Issue notice Mr. S. Pandey. Leonard counsel present accept notice on behalf of respondents number 1 and 2.
1 and 2.
For
the notices called for. Stop. It is submitted by Mr. S.N. that the issue involved is small in nature and relates to the prayer for filing an appeal pursuant to order dated. Which last order dated?
Well, it's 25/10/24.
25/10/24, which was order dated so and so passed by the Income Tax Appellate Tribunal, Lord the bench. I submit that the petitioner by the order dated so and so would be prejudiced in as much as directions have been issued that the CPC AO/CIT appeals to consider revised returns. I submit that if the appeal be filed for the CIT A, a form of appeal would be lost. So, next one is S. Pandey, Leonard counsel for the response. Please be allowed 2 weeks to obtain instructions. Yes.
The instruction only limited to the filing of physical revised return.
Yes, the instructions with regard to the filing of the revised returns before the competent authority.
The physical returns.
Physical.
Lordship. Highly pledged.
Item number 2.
Also by Lordship.
Yes, Dr. Mozika.
But I have instruction to withdraw this appeal also.
Okay. Dr. N. Mozika, DCI with so and so submits under instructions that him. Praise I'm allowed to withdraw the appeal. Stop. The same submits under instructions from the appellants. Only the matter stands on withdrawal. It's also under how much, what's the value? That memo is sacred, that means now we are applying it across the board.
At that point of time, the commissioner took a decision to file an appeal. Well, the present commissioner is saying this is not necessary.
Okay, yes.
It's below 1 crore.
1 crore. Below 1 crore. Now 2 crores above, no appeals, right?
Actually, it's 1 crore 51 lakh. That is a national litigation policy. That is not applicable here.
Yes.
Item number 3.
Yes.
Even this one also.
Withdraw. Right. Same order. Yes.
Item number 4.
May I please your Lordship?
Yes,
Lordship, in this matter, I am appealing for the item number respondent 226, Lordship. Lordship, during the course of the day, we are going to file our affidavit in opposition, Lordship.
Also in 5 and 6.
2 to 6, Lordship.
Oh, you're paying for 4 to 6?
2 to 6. Respondent 2 to 6. Item number 4, Lordship. 2 to 6.
Item number 4, you're paying for respondents 2 to 6.
2 to 6. For Income Tax Department, Lordship.
My lord, if they are filing the affidavit, 4 weeks time may be given to file the joint affidavit.
Yes.
And the stay may kindly continue.
You're Mr.
JP Moore.
Or JP Moore. Mr. JP Moore, on behalf of the respondents 2 to 6. Huh?
2 to 6, Lordship.
Please be allowed further. How much time?
During the course of the day.
Submits that the affidavit will be filed in the course of the day. Stop. Mr. A. Bansal. Appearing for the petition, please be allowed 3 weeks time. We give 3 weeks time to file the joinder to the affidavit.
4 weeks time may be given.
Why?
I have lost my mother.
Okay, 4 weeks time.
Last week.
4 weeks time is allowed for rejoinder. Lists accordingly. on so and so, interim order will continue to the next date. Yes.
Obliged, Lordship.
Deeply obliged.
Number 5.
Lordship.
Yes, Mr. Thakur.
Item number 3, ma'am.
They've withdrawn. They've withdrawn the appeal. Yes.
My junior and I'm in
Okay, we'll record your name. Mr. E. Thakur, number 3, is present on behalf of the respondent. Number 3. Yes.
Item number 5.
Lordship, in this matter, kindly allow 3 weeks time to file our affidavit in opposition, Lordship.
Correspondence number?
2 to 4, Lordship.
Yes, 2 to 4. Who's for the petitioner?
They give us a constant, but they are supposed to appear in a VC, but...
Yes. Anyway, Mr. G.P. More pre-response allowed. How much time?
3 weeks, Lordship.
Time to file affidavit. Obviously, on behalf of pays this thereafter or for the orders, yes.
Obliged, Lordship.
Item number 6.
May it please your Lordships. Lordships, I'm praying for some time to file a rejoinder, Lordship.
When did you
Lordship, I filed my affidavit,
When
Lordship.
did you file it?
Lordship, when the matter came up on the last occasion, Lordship.
Yes, MSSG Cruz. How much? 2 weeks?
Lordship, a week's time will be enough, Lordship. Lordship.
Please for 1 week's time to file joint affidavit filed by the respondents number 2 and 3.
2 and 3, Lordship.
Lordship, interim order may continue, Lordship.
Yes, also interim order, if any shall continue to next stages.
Highly
Much
obliged.
obliged, Lordship.
Any mention?
May it please your Lordship. Lordship, I beg to make a mention of item number 27, Your Lordship. For respondent number 1 and 2 on this matter.
What number?
1 and 2, Lordship.
Lordship of state respondents. Lordship of state respondents.
27.
This one.
You have no objection?
No objection.
After 2 weeks?
Lordship.
Yes. Yes.
Very please, Your Lordship. Your Lordship, item number 34, Lordship has heard only as a mercy, I think, that's for the insurance. That case, that 50% deposit was there. So, at Your Lordship, if you can direct, I think, then they can use it, because the question is not to take back the 50%, already it is there.
Because I believe both sides have already finished submissions.
No, I think I've totally forgotten. I think we'll have it. Let's have it for 1 week. We'll dispose it of next week.
As you wish.
Yes.
Yeah, please, Lordship. I humbly pray for item number 6, Your Lordship, for adjournment.
Number?
Number 36, my Lord. It's a joint request with.
Okay, 2 weeks, yes.
Lordship, similar prayer for item number 37. Here we are, some negotiation is going on between the petitioner and the state respondent. I have informed the state respondent also.
My Lord, we have no instructions based on that.
So if they are taking back, then I may withdraw also.
Let's come after 2 weeks.
Lordship.
Team lead, ma'am.
Lordship.
Lordship, similar prayer for item number 29, 31 and 32. These are connected matters, Your Lordship.
What, 29, 30?
29, 31 and 32, Lordship.
What is matter?
Policy for
29, 31?
and 32.
Even they have to substitute the respondent also, I think. At least after 2 weeks, petitioner given liberty of substituting the respondent. Yes. Since retired, yes.
28 and print sometime.
28, yes.
Lordship.
Yes.
Your Lordship, I beg to mention item 30.
Is that construction of the river?
Yes, Your Lordship, we require some clarification from the department which we are awaiting.
Suna. Oh. Yes. What clarification required?
Your Lordship, the guidelines, there's some confusion with the guidelines, Your Lordship, so we just require some
But then
clarification.
he also was confused himself last time.
No, now I'm no longer confused. Now they are confused.
They were not confused last time. They said you are not within the prohibited zone, and you said you were.
Yes, on that date, because I just received in the morning, my lord, that.
Okay, let's after 1 week to allow the councils to clear the confusion. Yes.
Obliged, Your Lordship.
I beg to mention item 35. Mr. Devnath is the other side.
Where's the Devnath? Inform him.
After 3 weeks, Lordship. Hello.
Yes. Yes.
My Lord, I beg to mention item number 39, my Lord.
Where's
The
the
respondent
city
number 5, my Lord.
Yes, you have objection.
Your Lordship, I just received now, Your Lordship, the affidavit for them. So I would like to go through it.
Okay, 2 weeks, yes.
I'm like,
Yes.
Item number 1.
May it please your Lordship. Lordship, this petition is for non-compliance of the judgment and order dated 18/2/2025. Lordship, 18/2/2025. Lordship, annexure P1, page 13.
18. Where's the annexure?
P1, page 13, and the operative part is at page 23. Lordship.
Yes.
Lordship, I may be allowed to read. We dispose of this appeal by affirming the judgment and order of the London single judge made on 5th April 2024. We direct the appellants to return the seized gold to the respondent within 4 weeks of communication of this order. We also make it clear that on the subsequent events, the appellants are free to take.
You have given the gold till now?
No, Lordship.
When does the order pass?
Lordship, it has passed on 18/2/2025.
Mr. Dharmani, take accept notice. This is the.
As bring the notice can be issued.
Okay, heard Mr. Beatep. This submits that. This application, this content application directed against. Oh, it's for. I'm sorry. Heard Mr. Beatep issue notice. Stop returnable in 3 weeks. Let notice issues to contempt proceedings are drawn up against the respondents' name here and here. List on so on. Yes.
All right.
Item number 2.
This is quasi covered case, Your Lordship.
Yes,
this is quasi covered case. The petitioners are seeking benefit of extension of the judgment passed by Your Lordship on 17/2/2025, Rector 8, page 272. They have been obligated as having the warrant, Your Lordship, and thereby they have been denied treating the application as promotion. And Your Lordship recently passed the judgment, that is Rector 8, page 272, except the left out and closed my lord, and the relevant page is 277.
2 weeks time I'll have instruction.
Let me get instructions. Heard Ms. M. Chanda issue notice. Robin Mozika, which also present acceptance of our respondents no further to call for. Stop submitted by Mr. M. Chanda that this case is very covered and that this court by order in where's that order?
Page 272.
This court
WC number 418 of 2024.
WC 418 had issued directions. Actually, would cover the case of the petition. Stop list after 2 weeks for instructions. But dispose of next after 2 weeks.
Item number 3.
May it please Your Lordship, on behalf of the petitioner, agree because for non-disposal of my representations, Your Lordship, I'd like to draw your kind attention, Annexure 7, Your Lordship, of the petition, page 61.
Page
61.
Regarding
subject is very important, Your Lordship.
One family member donated some land.
Yes, yes.
And what have they built on the land?
What happened is that prior giving them my representation, Your Lordship, PHE respondents, they simply laid down the main water pipeline in my land. That also without my knowledge, without my consent. Thereafter, there's no other option. I have to also file the representation before them. This is the first representation. Another that subsequently the second representation. And the third representation also I filed before the DC office. I mean DC because
what's
this
the representation regarding for job?
Yes, Your Lordship.
But what means that did you send agreement with the state respondents that you donate the land or something for the pipe?
Without giving the
no. Did you sign an agreement?
No, nothing as such.
Then your rights of full agreement. Now, if they've taken the land, if according to you unlawfully, then you have other remedy.
No, my only submission is that I'm not trying to fight against, because for the public interest, we are not against that. Why? Because there's a scheme.
How big is the land is taken from you?
It's about, I'll just Annexure 5, Your Lordship.
See, how this system works. I mean,
no, it's
I'm not wrong. In other cases, is that you give your land to the government, they set up PHC or a water tank or something like that.
Yes, it's right.
Then, in lieu of the donation that you've made, then they say, okay, fine, we'll appoint one if families are grateful.
I'm willing, Your Lordship. I'm willing, Your Lordship. But they have not given me any notice, no knowledge, no information, Your Lordship.
Where's have any next photographs?
Yes, Your Lordship.
This is the map. Who drew the map?
Yeah, this is the map. We're talking about the terrestrial map, Your Lordship.
This is
Annexure 5.
6.14 meters.
Yes, Your Lordship.
Yes, Mr. Abraham, you take instruction. Yes, heard Mr. S. Walang will contemplation issue notice. Mr. Abraham H. Abraham is present except on behalf of
all the respondents.
All the respondents.
Necessary stuff. A list after 2 weeks for instructions affidavit.
Are you obliged?
Yes.
Item number 4.
Lordship, I appear for the petitioner in this matter.
Yes.
His Lordship, in this case, my candidature to the post of Havildar Clerk has been cancelled on account of an FIR which is pending against me, which is now against the judgment of the Honorable Supreme Court.
Yes, you take notice. Yes. Your name, sorry?
Sahila Lamba.
Sahila Lamba. Okay. Her MSSK Lamba, like also the petitioner. Issue notice to Mozika with so and so, except we have all the respondents.
All the respondents.
No, for them to respond list after 2 weeks for instructions affidavit is.
Open.
Item number 5.
It is, Lordship. Lordship, this is that Yatra matter. On the last occasion, I understand the respondents have raised an issue of maintainability, an issue based on the fact that we have not enclosed the constitution of the society, etc. We are required to bring those documents on record through an affidavit, if Lordship allows us to file an affidavit.
1 week's time.
1 week's.
Yes, Mr. Ezra Praise Funds allowed 1 week's time to bring an affidavit certain necessary materials is support of this case.
Alright.
Item number 6.
They should go to the council first. Well, Lord, here the grievances of the petitioners is against the order of the same. Now, an appeal, because Section 3 of the Laka Act says that it has to be approved. Any action by the same has to be approved by the council.
What happened here, Mrs. Suna?
Yes, my lord. I would agree with what my learned senior has submitted, but my lord will appreciate the fact we have come before this honorable courts not only against that order, but against the complaint which was filed against us by the private respondent numbers 6 and 7.
Let the status quo be maintained, my lord.
Yes,
My lordship has already given a status quo order, and we will examine.
Who is appearing for the private respondents? For?
But my lord, it can be disposed of, subject to concern.
What about 8?
5.
One second. Let's get
my lord, my only prayer is that I was not heard.
You're not heard?
Before the respondent.
Yes, 1 second. Now, one state is whom?
State is there, your lord.
1, 2, 3, 4 state, right?
3 and 4 state.
Yeah, 1, 2, 3, 4 state.
5 it
1,
is.
2, 3, 4 5 is who? Who's 5?
5.
You're Mr. Champlian. Oh, sorry, Mr. Pishati. Yes, 6.
6 and 7.
Here is Soldar, Mountain Bridge, and Sketry. And 8 is Mr. Dingdo. Yes, Mr. P. Shati. The council's appearance today on behalf of respondent number 5. Similarly, Mr. T. Dakhar has an appearance today on behalf of 6 and 7. Mr. T. Leonard of Senior Council present on behalf of respondent number 8. As such, notice is complete on all the parties. What is your prayer?
My lord, kindly come to my prayer, page 18, number 2. My only prayer is only to remand back the matter with a direction to the respondent number 5 to hear the case.
It is submitted being aggrieved with. Where is that order you agree with Proceedings order?
20.
Page
64.
64.
Being aggrieved with an order dated
19/1/2015.
16 May.
1?
16 May.
16
May.
16 May 2014.
16/5/2014. Passed by the respondent number 5. With regard to the demarcation or the what with the
creation of
village
of the petitioner village
or the petition.
Nokandang village.
You agree with the creation of a village?
No, I'm
derecognition.
Derecognition.
Oh, being agreed with derecognition of the petitioner's village is before this court, alleging that the opportunity of being heard was not given to the petitioner, though in the judgments and orders of this court dated 13/11/2013, passed in WC number 44,012, and order 16/5/2014 passed in WA number 40. Where is that?
48.
Page
39.
Page
39. 39.
See, I'm just listening to your submission.
Yes.
So I hope everything's correct. Yes.
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 That I have not received the communication filed by the petitioner.
It doesn't matter.
I can show, my lord. I have filed.
The relevant portion is 41.
You were the appellant there. Yes. No. Yeah. Given. Pass in the writ appeal number 48,013. Clear directions have been given that the respondent number 5 was to take a decision on the representation made by the writ petitioner. Next by Mr. S.M. Suna submits that. What's your submission? Yes?
We have filed an representation before the respondent, but
the representation has already since been filed before the respondent 5. But
dated 14 June 2014.
On 14 June 2014, but the same has not been consented to,
and moreover, no opportunity of hearing.
And however, the impugned order dated 16 May 2014 had been passed. He therefore submits that the writ petitioner would be satisfied if a due opportunity of hearing is given with regard to the derecognition of the petition's validity term. Next, Mr. P. Shati, appearing for the respondent 5, has however submitted that the respondent 5 could not take up the representation of respondent 5 did not receive any representation from the petitioner. As such, there was no question of granting the opportunity of hearing. Then, Mr. Dingdo, you say that let them go to the council against the order of approval.
Yes, because the district council has to approve any decision of this.
The next one, Mr. T. Dingdo, say council with so and so for the respondent 8 has however submitted that in the scheme of things, an order of the CM, in this case respondent 5, in such matters has to be given the approval of the executive committee before the same is to be effective. The incident case submits no such approval has been obtained, which maybe has compelled the petitioner to come for this court. He therefore submits that the petition may perhaps be disposed of by allowing the
directing the respondent to hear me, my lord. Rehear the matter
afresh. By directing the respondent 5 to hear the matter afresh and pass orders thereon after affording adequate opportunity. Having heard the counsel for the parties, it appears that this one issue is limited only to the grievance of the writ petitioner, that with regard to the derecognition of Nongkandang village in the entire proceedings which had taken place for respondent 5, they were not heard. This court has also perused the orders passed by this court in writ appeal number 48,013, wherein it has been directed that the petitioner, that the respondent 5 dispose of the representation of the petitioner. But as this has not been done in the fitness of things, this writ petition is therefore disposed of with the direction to respondent 5 to rehear the village case number 1, 2014, and reconsider afresh the representation filed by the writ petitioner. Writ petitioner, as submissions have been made that the copy representation is not before number 5, the writ petitioner is permitted to file a fresh representation, which shall be considered in accordance with law. Time period: it is expected that the said matter be taken up, disposed expeditiously by the respondent number 5. Yes. Writ petitioner stands disposed of.
Meanwhile, my lord, status quo be maintained because complaint is
earlier by this court, in order that the public not suffer. Status quo shall be maintained as regard the schemes which they are enjoying presently.
We are not
Depriving.
We are not depriving them.
Exactly. Fine. Let status quo maintained until you know. Yes.
Apply a lot.
Much
Next.
Item number 7.
Please, Your Lordships.
Yes.
Your Lordships, it is listed for the miscellaneous application 16 of 2024. It's a perjury application, Your Lordships. We had.
This is Ali Akbar.
No, Your Lordship, this is John Marak. Item 8 would be Ali Akbar.
Yes.
Yes, Your Lordships.
No.
We're ready. We're ready.
No. What is this application? And the same one that you said regarding perjury?
Yes, Your Lordship.
So they have filed the application alleging that I have perjured myself.
What has been given by this court regard to that perjury fact in the earlier matter? No. Is the orders in the other cases similarly which you had filed earlier on?
It was another, yes, it was EP2, I believe, Gavin.
Has that been decided?
Your Lordships, not right now, because I think for in that matter, Your Lordships, it has been listed for the cross-examination for tomorrow itself, Your Lordships. In that matter.
Yes, Ms. Jindal. Are you willing to pursue this matter, or you're just taking the court's time?
More than willing, my lord. More than willing, my lord. We've been anxious to get this matter disposed of, or at least moving.
You do not demonstrate that when the matters have been taken up from time to time.
Our intent, my lord, is evident from the fact we are present on every date, my lord. We are present on every date. This petition has been filed, I would say, only to stall the matter. In any event, we are thankful that my friend is present today. This petition, my lord, it will not take much of Lordship's time to be disposed of.
Yeah, I'll give you 10 minutes.
Well,
reply also.
She has to
5 minutes. You start. Yes.
Please, Your Lordships.
Yes.
Your Lordships has the application.
That is, sir.
It's 16 of 2024, Your Lordships.
Yes.
Yes, Your Lordships.
Yes.
Yes, Your Lordships. So, Your Lordships, we had earlier moved Order 7 Rule 11 application in this present petition, and Your Lordships were pleased to dispose of the application by order dated 19th of June 2024, Your Lordships. And the order is annexed as an Annexure 3 of my application, Your Lordships, at page number 31. The relevant paragraphs, Your Lordships, page number are at page number 37, para 8 and para 9.
Yes.
Having heard the learned counsels for the parties in conformity with the earlier judgments of this court passed in the same issue, the court deems it fit that at this stage only the objections as to the presentation of the election petition be considered, and the other allegations with regard to attestation, etc., be taken up at a later stage consequent upon any further or future orders that will be finally passed as to whether this election petition was presented as per the requirement of Section 81, Clause 1 of the RP Act. An overview of the contentions, allegations and replies thereto, as presented in application, show cause and arguments of the respective counsels, it can be seen that the crux of the matter lies on the issue as to whether the election petition was presented in the manner prescribed by the law on 21st of March 2023 before the stamp reporter. It is noted that there is some confusion as to who is the stamp reporter before whom the election petition was presented and whether the election petitioner was personally presented. As has been held by this court in the so-and-so case in its order dated 31st October 2023, dated so and so. In the instant case also, it is seen that it would not be possible on the basis of the pleadings to come to any conclusive findings as to the correct presentation of the election petition. Accordingly, this court deems to fit to take up the issue of presentation of the election petition as a preliminary issue for consideration. The objection that the instant application is filed without leave of this court is overlooked and not considered. Your Lordship, so in the para 9, Your Lordships has duly recorded that due to the confusion with respect to the name of the stamp reporter, the present case was referred for the cross-examination. In view of this order, Your Lordships, the petitioner had filed their evidence affidavit dated, which is at page number 25, Your Lordships. It is dated 11th of September 2024.
Yes.
At page number 28, Your Lordships, that is para 7.
11th of September.
11th of September, Your Lordships. Page number 25 is the evidence affidavit filed by the petitioner.
Page 25.
Please, Your Lordships.
Are you sure the correct page?
Yes, Your Lordships.
What page?
Page 25 is the court fee. Page 26, the deposition begins.
Where's deposition? Where's the deposition? Not the file.
It is annexure A2.
No, it's not the file. It's not the file. It must be somewhere else.
Do we have the extra copy? The application. This here.
This is from Bagmara, right?
I can pass on the evidence affidavit, Your Lordships. I have the original certified copy.
Huh? No, that should be there.
We don't have the application. This is the evidence affidavit.
Just check. John,
or I can also pass the application, Your Lordships. I have the entire application with me.
Yes, you just refer to this. It must be there. It can't be missing. Yes, it's here. You take this part. 4th September. Yes.
Your Lordships has it.
Yes.
Page number 28, Your Lordships, para 7.
We don't have serial pagination. You have to go by the application itself, the position itself. Yes.
There is some confusion.
But this one's only 4 pages, 5 pages. The deposition.
Yes, Your Lordships, only.
You refer to that kindly.
5 pages, Your Lordships. Then, Your Lordships, the page 4 of the evidence affidavit and para 7. Para 7 reads, Your Lordships, that I have personally presented the election petition before the stamp reporter of this honourable court. This is important, Your Lordships, namely Srimati Sunita Lingskor on 21st of March 2023. I was accompanied by my friend, Mr. Iraq R. Marak, and my advocates, Mr. Nongdu and Ms. Raji, who were present when I personally presented the election petition to the stamp reporter of this honourable court on 21st of March 2023. Your Lordships, this paragraph mentions the name of the stamp reporter as Sunita Lingskor. Now, Your Lordships will have the show cause reply dated 4th of July 2023. In the application, it is at page number 9, Your Lordships, that is annexure A1.
Show cause reply. Final 25th, 11, 24.
This is also page
25/11/2024. Show cause reply.
I have the extra copy, Your Lordships, of the application then.
I think we have to do something with pagination because it's all scattered all over the place. Huh? 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 18 guy 16 miscase no miscase number 16 show huh? Can you kindly pass over this 16
Please, yes.
Yes, show cause reply filed on 25 and 24. Yes.
Yes, Lordships.
Yes.
Now, the relevant page is, Your Lordships, page 7 of the show cause reply and para 11.
Page 7.
Yes, Your Lordships. Para 11.
Yes.
It reads that the averments made in para so and so are entirely false, concocted, unfounded, frivolous, misleading, and denied. It is humbly submitted that the petitioner respondent herein has himself personally presented the election petition before the Assistant Registrar, Srimati S. Lanong of this Honorable Court on the date of filing, that is on 21st of March 2023, and as such there is no contravention of Section 81. Your Lordships, in the evidence affidavit, they provide the name of the stamp reporter as Srimati Sunita Lingscott, and in the show cause reply, Your Lordships, which was filed prior to the evidence affidavit, Your Lordships, the name is different, that is S. Lanong. Your Lordships, my case is, and in view thereof, the present application has been filed, which is listed before this Honorable Court, Your Lordships. My submissions are, Your Lordships, it is quite apparent from both the paragraphs mentioned, one in the show cause reply and another in the evidence affidavit, that it is false. The statement which they have given is, Your Lordships, my submission is that the entire election petition, the entire intention of this Honorable Court to refer the matter for cross-examination was to ascertain the truth. The truth whether the provisions of Section 81 Clause 1 of the Representation of People's Act were duly complied with. The truth whether the presentation was made, whether it was a personal presentation, and lastly, that the personal presentation was made before the appropriate officer, that is the stamp reporter, Your Lordships. So, which is also apparent from the observations made by this Honorable Court in the order dated 19th of June, Your Lordships. Now the purpose of the filing of the election petition fails, and it is defeated when the stamp reporter before whom the personal presentation was to be made, the names vary, Your Lordship, which is very much apparent, and it is on the face of it, Your Lordships, they are trying to mislead this Honorable Court. And also, Your Lordships, both the statements have been made on the duly notarized affidavits. They have sworn before the oath commissioner. So it definitely, without any dispute, it becomes the part of the evidence, Your Lordships. It becomes part and parcel of the evidence. Now, Your Lordships, before moving on, Your Lordships, proceeding further, in this application, Your Lordships, I would want to place on record the judgment. This is State of Punjab versus Jasbir Singh. This is a judgment by, one more copy. Here. This is a judgment passed by the three-judge bench, Your Lordships. It is a 2022 judgment. It is with respect to whether preliminary inquiry and opportunity of hearing is to be granted to the would-be accused or not. Your Lordships, the first paragraph, in the first paragraph, the first issue was framed by the Honorable Supreme Court of India was whether Section 340 of the CRPC mandates a preliminary inquiry and an opportunity of hearing to the would-be accused before a complaint is made under Section 195 of the Code by a court. Your Lordships, in para 7, the Honorable Supreme Court discusses the reference order simultaneously noted the observations in the Constitution bench of this court in Iqbal Singh Marwa versus Minakshi Marwa, which was post the judgment in Pritish case, but prior to the judgment in Sharad Pawar's case. In this behalf, the extracted portion of in 23 of the judgment reads as under. This is relevant, Your Lordships, because after discussing this, the Honorable Court answers the question referred to in the first paragraph in negative, Your Lordships. In view of the language used in section 340 CRPC, the court is bound to make a complaint, not bound to make a complaint regarding commission of an offence referred to in section 195(1)(b), as the section is conditioned by the words "court is of opinion that it is expedient in the matter of in the interest of justice." This shows that such a course will be adopted only if the interest of justice requires, and not in every case. Before filing of the court complaint, the court may hold a preliminary inquiry and record a finding to the effect that it is expedient in the interest of justice. That inquiry should be made into any of the offences referred to in section 195(1)(b). This expediency will normally be judged by the court by weighing not the magnitude of injury suffered by the person affected by such forgery or forged document, but having regard to the effect or impact such commission of offence has upon administration of justice. It is possible that such forged document or forgery may cause a very serious or substantial injury to a person in the sense that it may deprive him of a very valuable property or status or the like, but such document may be just a piece of evidence produced or given in evidence in court, where a voluminous evidence may have been adduced and the effect of such piece of evidence on the broad concept of administration of justice may be minimal. In such circumstances, the court may not consider it expedient in the interest of justice. Your Lordships, after discussing in para 10, Your Lordships, interestingly, both the judgments in Pritish case and the Constitution Bench judgment in Iqbal Singh Marwa's case have not been noted in the order passed in Sharad Pawar's case. The answer thus to the first question raised would be in the negative. So, Your Lordships, in the present case, they have been granted opportunity to file the reply, which is in contravention of the findings of this Honourable Court, Your Lordship, of the Honourable Supreme Court of India, Your Lordships. Now, moving on, Your Lordships, now coming to their reply which they have filed to my application.
Yes.
In their reply, Your Lordships, sorry, just the copy of the reply. In their reply, Your Lordships, firstly, they have admitted that there is an error in recording the name. So, directly, indirectly, they are conceding to the fact that they have made a false statement in their affidavit, Your Lordships. Now, Your Lordships, kindly turn to page 6 of their reply.
Yes.
Your Lordships, the reason what they mention that which led to the confusion in recording the names is not supported by any document, Your Lordships, and I will show it from their reply only, Your Lordships. Page 6, it reads as, in the present case, it is humbly submitted that the statement made in paras 11 and 14 of the show cause reply dated 4th of July in MCEP number 18 of 2023, which referred to Srimati S. Lanong as the stamp reporter of this Honourable Court, is due to inadvertent typographical error insofar as the surname of the said stamp reporter is concerned. And the same is in no way intentional or deliberate on the part of the election petitioner respondent herein. The election petitioner at the time of filing the said show cause dated 4th of July 2023 was of the bona fide belief that the stamp reporter, who is fondly called Kong Suni, before whom the connected election petitioner was personally presented, has the surname Lanong. Your Lordship, this argument has to be outrightly rejected by this Honourable Court. This is a very serious, in fact, Your Lordships, when we argued Order 7, Rule 11, we had placed on record G. Sriva Reddy judgment, Your Lordships. In that case, Your Lordships, the Honourable Supreme Court had held that election petition is a very serious matter and it has a serious consequences, Your Lordships. So whatever has been laid down in the statute is to be followed strictly, Your Lordships. So in good faith, in order to confirm the name of the stamp reporter, the election petitioner respondent herein had sought for the said information by way of an RTI application. So, Your Lordships, initially they filed a show cause reply dated 4th of July 2023. Now, when they have to file the evidence affidavit, they move an RTI application. Now, it also depicts their intention, Your Lordships. Now, and wide reply issued by the concerned PIO, it was inter alia made clear that the stamp reporter, who is fondly known as Kong Suni and before whom the election petition was personally presented, was Srimati Sunita Lingskor and not Lanong. Your Lordships, this is a clear admission on the face of it. They have admitted that they have made a false statement. They have admitted that the stamp reporter allegedly they made a personal presentation before does not exist. Now, Your Lordships, further on, they admit that in at page 7, Your Lordships, in fact, at the time of hearing of the said MCEP number 18 of 2023, it was clarified to this Honourable Court by the election petitioner that the connected election petition was duly presented before Kong Suni. Your Lordship, no such statement was earlier made by them. Now, who is the stamp reporter of this honorable court? As such, it is apparent that the said error is surname of the stamp reporter is a case of bona fide mistake. First, they say it was Kongsuni, the name she was being referred to. Secondly, they say that there was a confusion in the surname. Now, that the said error in surname of the stamp reporter is a case of bona fide mistake of surname, and the same is in no way intentional or deliberate, Your Lordships. This submission, Your Lordships, in support of this submission, they have replied to the, this is the reply of the RTI, Your Lordships, which is at page number 15, Annexure 1.
Yes.
This at what they are trying to indicate, Your Lordships, I think at para B. Regarding question number 3, the answer is Srimati Sunita Lingskor. Although what is the question number 3, it is nowhere. The application has not been annexed, Your Lordship, so it is also not clear what exactly the question was. But what they are trying to make it, what they are trying to indicate, Your Lordship, that Sunita Lingskor was the stamp reporter before whom they have made the alleged personal presentation, Your Lordships. Now, this was filed after the show cause reply was filed, and when they moved the present.
The evidence and affidavit you can base that.
Please, Your Lordships, evidence affidavit.
Like John Mara.
Page number 25 of my application, Your Lordships.
That's para 7.
Para 7, Your Lordships. Para 7, Your Lordships. And in fact also, Your Lordships, name of S. Lanong in their show cause reply, it is not that it is mentioned only in one paragraph. It has been mentioned several times.
Yes, but how to reconcile this?
Your Lordships, I'm very sorry. Your Lordships, also I'm relying on certain judgments if I'm allowed to place on record, Your Lordships. Yes.
So the entire thrust of your application.
Please, Your Lordships.
Entire thrust of your application is on this.
Yes, Your Lordships, and I'm also relying on certain judgments. It is Rasika Lal Manik Chand, Your Lordships. Paragraph 66, Your Lordships. It is basically with respect to the how the evidence is to be taken. It basically, this judgment deals with the fact that once the affidavit is filed and once it is sworn before the oath commissioner, it becomes the part and parcel of the evidence now. Now they cannot simply come up with this statement that it was an inadvertent error or it was a bona fide error. Page 66, Your Lordships, as to how the para 66, Your Lordships, as to how the evidence is to be taken in appealable cases is provided in Order 18, Rule 5 of the Code. The provision is how evidence shall be taken in appealable cases. In cases in which an appeal is allowed, the evidence of each witness shall be taken down in the language of the court, in writing, or in the presence and under the personal direction and superintendence of the judge, or from the dictation of the judge directly on a typewriter, or if the judge for reasons to be recorded so directs recorded mechanically in the language of the part in the presence of the judge. The purpose and objective of Order 18, Rule 4 of the Code is speedy trial of the case and to save the precious time of the court, as the examination in chief of a witness is now mandated to be made on affidavit with a copy thereof to be supplied to the opposite party, which has happened in the present case, Your Lordships. If Your Lordships would directly come to para 77.
Yes.
Para 77 reads, for all this, it cannot be said that in Amir Trading Corporation Limited, it has been laid down as an absolute rule that in the appealable cases, though the examination in chief of a witness is permissible to be produced in the form of affidavit, such affidavit cannot be treated as part of the evidence unless the deponent enters the witness box and confirms the contents of the affidavit are as per his say and affidavit is under his signature. But where the examination in chief of a witness is produced in the form of an affidavit, such affidavit is always sworn before the oath commissioner or the notary or judicial officer officer or any other person competent to administer oath, the examination in chief is thus on oath already, your lordships.
But the other contract judgments also to this.
Please, your lordship.
The other judgment also, which anyway, that we examine.
No, your lordship's my only submission is that once they have deposed before this honorable court, and there are two affidavits. On both the affidavits, they have come up with the contradictory statements, and in that regard, your lordships, I am carrying the judgment that if contradictory statements are being made on two affidavits, it means one of them is false. And then it becomes a fit case for initiating perjury against the deponent. Your lordships, the one who has made the false statement. Now, your lordships, another judgment I am relying upon is
yes.
This is your lordships on this very issue only, and this is Umrao Lal versus State. This is passed by the Honorable High Court, your lordships. Honorable Allahabad High Court. Para 12, your lordships. It deals with the two contradictory statements only. Para 12, your lordships.
Yes.
There are authorities which will be mentioned either holding that when a witness admits having made a previous statement incorrectly and corrects himself later, which is happening in the present case, your lordships, they have admitted that they have made an incorrect statement, and now they are trying to correct it by the subsequent affidavit, which will be mentioned either holding that when a witness admits having made a previous statement incorrectly and corrects himself later, it is not expedient to prosecute for perjury. When, however, a witness makes two contradictory statements intentionally, there is nothing to show that the earlier statement was wrong and was corrected by the subsequent statement, and he does not admit that he had committed a mistake in making the earlier statement. And when the prosecution charges him in the alternative with making one of the two statements falsely, he must be convicted for perjury. In the present case, the two statements made by the applicant were so contradictory to each other that they could not be reconciled with each other and could not both be true. One of them was bound to be false. The applicant deposed about matters which were within his knowledge, and that there was no scope for his making any mistake. It is not his case that the first statement was incorrect. In his statement as an accused, he stated that both the statements were correct. So it is not a case of his having made the earlier statement wrongly under a mistake and of his subsequently correcting himself by making the second statement. It is clearly a case of making both the statements deliberately, and when they are found to be irreconcilable, he must be convicted. Your lordships, in para 15, coming to the second contention, I find that it is quite immaterial that the two contradictory statements were made in the course of one deposition and one trial. If the first statement is false, the applicant committed the offence of perjury as soon as he made it. Now, your lordships, subsequently, the Honorable High Court deals with this situation where two contradictory statements were made, and the court held that even if it is proved that one statement is false, then the then the deponent has to be convicted under the proceedings has to be initiated under 340 CRPC, your lordships. The another judgment I am relying on is this is This is a very recent judgment passed by the Honorable Supreme Court, your lordships.
Yes. 24.
Yes, your lordships. Para 20.
What's the point in issue here?
This is with respect to the false documents being used when it was in knowledge of the deponent, your lordships. It is a general finding which is recorded at para 29, your lordships.
Yes.
Para 29.
Yes, to create.
Please, Your Lordships, to create or to assist creating false documents and to use them as genuine, knowing them to be false in the court proceedings, to falsely implicate somebody in the false proceedings filed in the name of the person who had no knowledge whatsoever about the same are the acts attributable to the offences punishable under the BNS 2023. They are also acts of fraud committed not only on the person sought to be falsely implicated on the person in whose name such false proceedings are filed without his knowledge and consent, but is a fraud committed on the courts. No court can allow itself to be used as an instrument of fraud, and no court can allow itself to be used as an instrument, its eyes to be closed to the fact that it is being used as an instrument of fraud. As held by this court in V. Chandrasekharan versus Administrative Officer, the judicial process cannot become an instrument of oppression or abuse or a means in the process of the court to subvert justice for the reason that the court exercises its jurisdiction only in furtherance of justice. The interests of justice and public interest coalesce, and therefore they are very often one and the same. A petition or an affidavit containing a misleading, inaccurate statement only to achieve an ulterior purpose amounts to an abuse of process of the court.
Right then, yes, Mr. Judge.
Please, there are two more judgments, Your Lordships. I am just passing on. These are on the same issues, Your Lordship. Section 340 CRPC.
Yes, Mr. Judge.
Lordship, I have two responses on law points, and two responses.
So first, how do you reconcile? You see, if you can't show reconciliation, then we have to take the other view, right?
Lordship,
if the two affidavits,
Lordship, I'll address that. I'll address that. Lordship, if I'm allowed to place my first objection against this petition, my objection, my lord, would be based on the provisions of the High Court rules, my lord.
Of the
High Court rules, Guwahati High Court rules, my lord. Now, High Court rules, Lordship is aware, Chapter 8, dealing with election petitions. Chapter 8A, Rule 10.
Yes.
Chapter 80, Rule 10, my lord, the requirement stipulated in Rule 10, Chapter 80.
1 second. Yes.
The requirement stipulated, my lord, in Chapter 80, Rule 10 is very clear.
6 rupees stamp.
All interlocutory petitions should bear a court fee of ₹6 thereon and may be filed before the judge with permission of his lordship. So the question before this honorable court is very simple. The question to be posed: was permission taken before filing this interlocutory application?
Yes.
Answer is very clear: no.
Yes.
So if no permission was sought to file this interlocutory application and consequently no permission was given, the miscase 16, which has been filed raising these issues, itself does not stand, my lord. Itself does not stand, itself is not maintainable. In the rejoinder that has been filed by them against our reply, they've tried to cover this point. Their rejoinder may kindly be looked at. Page 5 of the rejoinder, my lord. Page 5 of the rejoinder, para 4.
That the averments in para 5.
That the averments in paragraph 5 of the show cause reply are wrong and vehemently denied. It is submitted that the present application has been moved to initiate action against the respondent for committing the offence of perjury. It is a settled law that any party or person can move an application under section so-and-so of CRPC before the court where the alleged perjury occurred. Therefore, there was no requirement for seeking prior permission to file the instant application. Even further, Chapter 8A, Rule 10 of the Guwahati High Court rules does not mandate seeking prior permission, as it mentions the applications may be filed before the judge with permission of his lordship. Now, two responses have come to try and cover this glaring lacuna, my lord. One is, according to them, they are invoking Section 340 of the BNS, etc., and therefore they are not required to.
379, I think.
370.
Sorry, my mistake, my note.
70.
It mentions 340 in their para. In any event, their contention is, first contention is that they are invoking certain provisions of CRPC or BNSS, and therefore they are not required to comply with Rule 10. My humble, respectful response to that is that you may invoke any provision of any law, but at the end of the day, this is a proceeding, is an election petition governed under Chapter 8A of the High Court rules, my lord. So if the High Court rules require you to act in a certain way, you are required to act in that certain way. CRPC or any other law does not speak of whether or not permission is required before filing of any miscase interlocutory applications. It doesn't. CRPC is silent on that. Chapter 8A speaks very loudly, speaks very eloquently, my lord. And that requirement has not been complied with. The first reason given, that we have invoked CRPC, we are not required to comply with Guwahati High Court rules. My lord, that would be contemptuous on the face of it, my lord. They are definitely required to comply with Rule 10, my lord. The second response that they are extending is that the language employed under Rule 10 is that anyone wanting to file an interlocutory application, the application may be filed before the judge. In other words, according to them, there is a discretion that is vested on the petitioner, on the person filing the application. If he chooses, he may take the permission of Honorable Court, or if he chooses, he may not take the permission before filing a interlocutory application. My lord, this submission or this interpretation would cause chaos and violence to this to these rules. If that interpretation is allowed and may is to be read as giving a discretion to the person concerned to either seek permission or not to seek permission, then the same treatment will have to be applied to the entire Chapter 8A. So wherever may is used, it should be read as a discretion. So that will cause, as I said, violence and unnecessary chaos, my lord. If I'm just by way of example, the first rule, an election petition under Section 80A of the so-and-so Act may be presented duly verified. So does that mean you have a discretion to verify or not to verify that petition? No. May has to be read as must. Shall have to be verified. An unverified petition will not be entertained either by registry or by this Honorable Court. So to read may as affording some sort of discretion, some sort of choice, my lord, would not be
in the context of election petitions.
In the context of election petitions, in the context of these rules, my lord. That is my first objection. Petition itself, which they have filed, is not maintainable. Second objection, the second point which I'm raising for Lordship's consideration is, they want to...
One thing, Mr. General,
yes.
So glaring,
yes,
is glaring like the affidavits you file.
Yes, ma'am.
Are glaring. Can the court not examine that?
My lord will allow me to answer by saying no, but with all respect at my disposal, my lord. Yes. I'll substantiate why I'm saying no, my lord. My lord, and this brings me to my second objection. They are seeking my prosecution under Section 229 of the BNS, my lord. Now, Section 229 of the BNS, what it requires
229 or 379?
229 is the punishment for perjury.
Okay. 229?
229, my lord. Of the BNS, my lord.
Special summons?
Of the IPC, the new IPC, my lord, the BNS. Bharatiya Naya BNS. It's a little confusing. Even I get confused. 229, my lord. They're seeking my prosecution, or they're seeking punishment against me under 229. I'll just read the first part, my lord. 229, punishment for false evidence. Whoever intentionally gives false evidence in any stage of a judicial proceeding or fabricates false evidence for the purpose of being used in any stage of a judicial proceeding shall be punished with imprisonment. It goes on, my lord. I'm focusing on the first part, my lord. Whoever intentionally, I'll come to that part, my lord, gives false evidence. So there are three requirements, I would say, my lord, for me to be punished. First, there has to be evidence. There has to be evidence on record. Second, that evidence should be shown or should be proved to be false evidence.
Yes.
And third requirement is I should have tendered that false evidence intentionally.
Yes.
Now, what is on record, as pointed out by my friend and through the petition also, there is an affidavit, there is a show cause filed in the earlier proceeding, earlier miss case, where I have made a certain statement. There is an affidavit of evidence. That earlier show cause is also supported by affidavit. So in other words, it is an affidavit also. Now we have affidavit of evidence. The question before this Honorable Court is, are these three elements, these three requirements satisfied? First, my Lord, the first requirement is evidence. Evidence, my Lord, is defined under the Evidence Act, the new Evidence Act, that is BSA, my Lord, Bharatiya Sakshya Adhiniyam, BSA. Section 2 of this BSA, my Lord. Section 2, subsection E.
Yes.
Section 2, subsection E. Evidence means and includes all statements, including statements given electronically which the court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry, and such statements are called oral evidence. All documents, I need not read that. So on the face of it, at first glance, it appears that any statement made before a court, on affidavit or otherwise, would be covered under evidence. However, my Lord, the Supreme Court has clarified this position as far as affidavits are concerned, my Lord. This is in a 2013 judgment. If I can humbly place the judgment.
Yes.
This judgment, my Lord, para 31 may kindly be looked at.
31.
31, my Lord. 31 and 36. First 31, my Lord. I'll read, my Lord. It is a settled legal proposition that an affidavit is not evidence. Para 31, my Lord.
Sorry, yes, okay. Yes.
First, the second page, my Lord. It is a settled legal proposition that an affidavit is not evidence within the meaning of Section 3 of the Evidence Act, hereinafter so and so. Affidavits are, therefore, not included within the purview of the definition of evidence as has been given in Section 3 of the Evidence Act, corresponding, my Lord, to Section 2 of the BSA. And the same can be used as evidence only if, for sufficient reasons, the court passes an order under Order 19 of the Code of Civil Procedure. Thus, the filing of an affidavit of one's own statement in one's own favor cannot be regarded as sufficient evidence for any court or tribunal on the basis of which it can come to a conclusion as regards a particular fact situation. I move to para 36, my Lord. Therefore, para 36, therefore, affidavits in the light of the aforesaid discussion are not considered to be evidence within the meaning of Section 3 of the Evidence Act. However, in a case where the deponent is available for cross-examination, which I am, my Lord, the same can be, an opportunity is given to the other side to cross-examine him, the same can be relied upon. Such view stands fully affirmed, particularly in view of the amended provision of Orders 18, Rule 4 and 5 of CPC. In certain other circumstances, in order to avoid technicalities of procedure, the legislature or a court tribunal can even lay down a procedure to meet the requirements of it goes on, my Lord. I'm stressing on para 34 and 36. Which makes it very clear, Supreme Court has made it very clear that an affidavit is not evidence.
Per se. But the other judgments also say otherwise. Anyway.
My Lord, I'll just address that judgment also. I'll address that judgment. Focusing on this judgment, my Lord, evidence, affidavit is not evidence under Evidence Act or the BSA, my Lord. If that be the case, then the first requirement of 229 is not met. First requirement is evidence. There has to be evidence. Second requirement is that evidence should be shown or proved to be false.
Before the person dies.
Yes, my Lord.
After the evidence has been filed.
After it has been filed.
What is the status of that affidavit then?
My Lord, the law on that is...
He can't present an affidavit,
true,
in person or subject to cross-examination.
Yes, my lord. So the law on that point, my lord, going off on a slight tangent, my lord, the law on that point is that it would depend on the circumstances of the case. It would depend on the good judgment of the court concerned to whether or not to take that untested evidence, that uncross-examined statement as corroborative evidence, if not substantial evidence, only as corroborative evidence. To answer Lordship's pointed question, my lord, coming back to this issue, so the first requirement of 229 is not complied. So very clearly, the second requirement of false evidence being there, having been tendered, is also moot now. First requirement itself is not there, my lord. So as this 2013 judgment had clarified in para 36, if the witness is present for cross-examination, which Lordship may recall, I was present on one of the earlier occasions, the day this petition was filed, and he is cross-examined, then that becomes evidence. Then that becomes evidence. Then that would be the more appropriate stage for this honourable court to take a call to decide whether or not perjury has been committed by me in any form, my lord. But as on date, there is no evidence, my lord. There is no evidence. So very clearly, they cannot. The question of me tendering false evidence also cannot arise, my lord. That's my second point, my lord. Third point, and it's a very general kind of point. Lordship will kindly allow me to illustrate, draw up an illustration. If I make an allegation that somebody has lied, I make an allegation my friend has lied. My allegation is based on the fact that today she is saying something, 1 month previously she had said something else, something contradictory. Now, if my allegation is that this shows you have lied, you are lying, then it is incumbent on me to point out which of the two statements is correct. For me to say you are lying because that statement is correct, today you are lying, or today's statement is correct, that day you had lied, it is required for me to point out which statement is correct. Now, they are harping on the point that in my show cause reply, I had mentioned a certain name. In my affidavit of evidence, I'm mentioning a separate, a slightly different name. First requirement is point out which, according to you, is the truth, is the correct name. And because of that, it can be said that I am lying now, or I have lied in my show cause reply.
That'll be too far-fetched. Anyway.
My lord, the Allahabad High Court has touched on this matter. I'll also touch upon the Allahabad High Court judgment, my lord. My point is very simple, my lord. In their petition, or in their rejoinder, or in the submissions advanced by my friend today, there is not a whisper that this statement
is correct and B is wrong.
Exactly, my lord. Exactly, my lord. What has in fact come out through their petition and the submissions is, at best, there is a mismatch. There is a mismatch. There is a contradiction. Now, just to state the obvious, my lord, the very obvious, a prosecution can be launched against me for perjury, for lying. Prosecution cannot be launched against me for contradictions, my lord. And the Supreme Court addresses this in a judgment which I shall shortly place, my lord. That is my third point. And staying on this point, my lord, if I'm allowed to place this judgment.
Yes.
It's a very recent judgment from last year, August, my lord. The factual background is fairly similar to our background. Factual background, my lord, can be found at para 2. Para 2, I'll read, my lord. Impugned in the present appeal is the final order dated so-and-so, passed by the High Court of Uttarakhand at Nainital in bail cancellation application number so-and-so, whereby, although the said application was dismissed, it was observed that James Kunjiwal, the present appellant, had intentionally filed a false affidavit before the High Court, and as such, a direction was issued to the Registrar Judicial of the High Court to file a complaint against him. This, in a nutshell, forms the basis for this appeal. This is the background, my lord. Para 13, my lord. Para 13. Now, this judgment, my lord, examines section 193 that corresponds to 229. Section 193 of the old CRPC, my lord. Para 13. when prosecution should be sanctioned under this section by courts has been expounded on by a bench of 3 learned judges in so-and-so versus so-and-so. I'll read, my lord. The prosecution for perjury should be sanctioned by courts only in those cases where the perjury appears to be deliberate and conscious and the conviction is reasonably probable or likely. No doubt, giving of false evidence and filing false affidavits is an evil which must be effectively curbed with a strong hand, but to start prosecution for perjury too readily and too frequently without due care and caution and on inconclusive and doubtful material defeats its very purpose. Prosecution should be ordered when it is considered expedient in the interests of justice to punish the delinquent and not merely because there is some inaccuracy in the statement, which may be innocent or immaterial.
Yes.
So prosecution should not be allowed when there is only an inaccuracy in the statement, which is innocent or immaterial. Now, my lord, the statements which are before my lord, the two statements, what comes out as I submitted some time back is an inaccuracy, a contradiction, falsehood, lies do not come out, my lord. And question is that contradiction, is it innocent or immaterial? It is innocent, and this is obvious from the fact, my lord, that when we filed a show cause reply, we were under a certain impression. We were under the impression that the stamp reporter in question is Mrs. S. Lanong. After the show cause reply, when the matter proceeded, we filed an RTI reply. In the RTI reply, we were informed of the actual fact that it is Sunita Linkskor. So there is a mismatch in the title. S remains, my lord. S. Lanong was Sunita Lanong in our mistaken belief. That was the name, that was the stamp reporter's name. Having confirmed through RTI, having got the correct name, we put the correct name on record, my lord, Sunita Linkskor. So was it an innocent mistake? It was an innocent mistake. It was innocent for the reason that we do not achieve anything by making by putting a falsehood on affidavit, my lord, by putting a falsehood on affidavit. What remains constant, and this is important, what remains constant in both affidavits is our assertion, unrebutted assertion, that we presented the election petition physically to a stamp reporter. In the affidavit, in the show cause reply, unequivocally we have stated we have gone to a stamp reporter. In our evidence, we have stated we have gone to a stamp reporter. If there was a contradiction in that material respect, then maybe situation would be different. But in the immaterial respect, the lesser aspect of the matter, where there is a mismatch in the title of the stamp reporter, my lord, that would be amount to an innocent and an immaterial contradiction at best, my lord, for which no prosecution should be launched under any circumstances.
Just about other judges, you know that false statement made on oath or affidavit?
Yes, my lord.
The such thing that made a judicial proceeding?
My lord.
Statement before a court. It's from your judgment, paragraph 15.
The same paragraph, my lord.
Yes. So paragraph 15 of your judgment only.
Paragraph.
Sign 1 the 3 instances.
My lord, paragraph 15, I'll read, my lord.
Yes.
The 3 essential factors which can be said to be sine qua non for the application of section so-and-so as held in so-and-so are false statement made on oath or in affidavits, that such statements be made in judicial proceedings, or such statements be made before an authority that has been expressly deemed to be a court, deemed to be a court. Now, these are the requirements for one.
You're saying one is not a false statement. It's a contradictory statement.
It's a contradictory statement, my lord.
Okay.
It's a contradictory. It's a contradictory statement.
You tick the boxes.
My lord, if the false statement itself is not there, the others won't apply. I'll draw lordship's attention to para 16, my lord. Para 16 just clarifies the matter some more. Para 16, what we may conclude from a perusal of the above noticed judicial pronouncements is that, I'll skip one, my lord. Number 2, such proceedings should be initiated when doing the same is expedient in the interest of justice to punish the delinquent, and not merely because of inaccuracy in statements that may be innocent, immaterial. Number 3, there should be deliberate falsehood on a matter of substance. Now, number 4, court should be satisfied that there is a reasonable foundation for this charge with distinct evidence and not mere suspicion. So, my lord, there has to be deliberate falsehood on a matter of substance. Now, like I had submitted, it does not serve our purpose to have placed a deliberate falsehood before this honorable court, my lord.
To prejudice yourself, you mean?
To prejudice ourselves, to put ourselves in this position, in this uncomfortable position, my lord. And my lord, in that respect, what is very clear is that mens rea is important. My mens rea at the time when I made these so-called perjury statements, my lord. In that respect, I draw lordship's attention to the rejoinder that has been filed by the petitioner, by the other side. Rejoinder, my lord, there is a judgment which my friend has extracted for our benefit. That is at page 3. Para 6 of the rejoinder. I'll read, my lord. Further, in the case of so-and-so versus so-and-so, 2017, etc., by referring to the case of so-and-so versus so-and-so, held as hereunder, the mere fact that a person has made a contradictory statement, which I have made, in a judicial proceeding is not by itself always sufficient to justify a prosecution under section 199 and 200 of the Penal Code, hereinafter referred to as IPC. But it must be shown that the defendant has intentionally given a false statement at any stage of the judicial proceeding or fabricated false evidence for the purpose of so-and-so, 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 so-and-so. My lord, the point is very simple, that a mere contradiction is not enough. As per this judgment passed by the Supreme Court itself, my mens rea, whether I have intentionally given a false statement, is important, my lord. My last point, my lord. My last point is on the factual part of it. In my show cause reply, I had stated that I have given to the stamp reporter Srimati S. Lanong. In my affidavit filed after RTI information, my lord, I have stated I have given to stamp reporter Srimati Sunita Lingscore. So, like I submitted, my lord, my assertion that I have given to the stamp reporter is not changed, and that is the material assertion, my lord.
Okay. Yes.
Number 1. Number 2. Some confusion did exist, my lord, initially, as to the name of the stamp reporter, and if I'm allowed, with respect to draw lordship's attention to lordship's early order passed in the Order 7 Rule application, Order 7 Rule 11 application, para 9 of that order, my lord.
Read it. What is it?
My lord, the confusion was there in our minds, and lordship has acknowledged that there is some confusion. Para 9, an overview of the contentions, allegations and replies thereto as presented in application, show cause and arguments of the respective counsels. It can be seen that the crux of the matter lies on the issue as to whether the election petition was presented in the manner prescribed by law on so-and-so before the stamp reporter. It is noted that there is some confusion as to who is the stamp reporter before whom the election petition was presented and whether the election petitioner was present personally. Lordship, confusion
is not with regard to identity, but it's reflected in the order.
Yes,
confusion is with regard to whether you went and give the bench or the desk of the correct person, that's all. So because the rules say that you have to present for a stamp reporter.
The stamp reporter.
Now the confusion was there. Now because with regard to whether it's a deputy registrar or whether it's a stamp reporter, there lies the confusion. So if we have the preliminary evidence that we're taking, if we say this is the person present before at the relevant point of time, suppose not a stamp reporter, then your case goes.
My lord is right, but my point still remains, my lord. There was some confusion at that time.
Confusion on your part with regard to names,
as to the identity.
The confusion with regard whether you present before the correct.
Yes, my lord. Yes, my lord. And lordship is right. Lordship is
intended to.
Lordship is right. Lordship is right, and that confusion will be clarified at the time of after the evidence is recorded, my lord. Now, my lord, the confusion did exist, my lord. The confusion did exist, and it is only because of this confusion that one name, S. Lanong, came in the show cause reply, and the correct name came in after the RTI, my lord. Now, in this respect, very quickly, if I can go back to the judgment of Allahabad High Court relied on by my friend. Now, that judgment says, there are 12 of that judgment. It's that 1953 judgment.
55 or 53?
53, my lord. 1953 SCC online, Allahabad. Now, that judgment Para 12.
1 second. Yes.
I'll just read 1 or 2 lines, my lord.
She has read para 12.
Para 12, my lord.
Yes.
I'll read, my lord. There are authorities which will be mentioned later, holding that when a witness admits having made a previous statement incorrectly and corrects himself later, it is not expedient to prosecute him for perjury. I'll just pause, my lord. So if a witness makes a statement and later admits that he made a mistake, no prosecution for perjury is expedient, my lord. Now, have I admitted my mistake, my reply, my lord? Page 6 of my reply. Page 6 of my reply. Page 6, the third line, my lord. In the present case, it is humbly submitted that the statement made in so-and-so and so-and-so of the show cause reply dated so-and-so in so-and-so, which referred to Srimati S. Lanhong as the stamp reporter of the Honorable Court, is due to inadvertent typographical error insofar as the surname of the said stamp reporter is concerned, and the same is in no way intentional and or deliberate on the part of the election petitioner respondent herein. The election petitioner respondent herein at the time of filing the
Why
section...
typographical error? It's inadvertent ignorance about the correct name of the person.
Presence of typographical error in the reply is itself a typographical error. It shouldn't have... It's inadvertent. It was inadvertent, my lord.
Typographical means that you know.
Typographical is, I would say, my lord, it's more a spelling mistake kind of error.
That means what you know who the person is.
Yes, my
okay,
lord.
you don't know who the person was. Anyway,
Yeah.
okay.
Yes,
You finished?
Yes, I'll just take a minute more, my lord, if lordship allows.
No replies.
Just 1 minute.
You want to reply? Because we have taken enough time.
2 minutes.
Yes.
No, lordship, if I can quickly sum up, my lord. The judgments relied on by my friend. That Allahabad judgment, my lord, I have addressed, my lord. Para 12 comes to my aid rather than the other side's aid.
Yes.
2024 Supreme Court judgment, my lord, relied on by them.
Yes.
Is of no assistance. It speaks of false documents. 2024 Supreme Court, the latest judgment cited by them, speaks of addresses a circumstance or a situation of false documents. Yes, para 24 actually. It speaks of false documents, no relevance, no connection. 24, I believe, my lord. 24 is the, if I can. 29, sorry, my mistake, my lord, my mistake. 29, my lord. 29.
Oh, she had read 29.
Yes, my lord. 29 concerns false documents. Completely different situation, my lord. Has no, this judgment, my lord, cannot apply, should not apply. Yeah. And lastly, my lord, the Rasika judgment of 2012.
Yes.
To the effect that affidavit doesn't become evidence.
Para 66.
66, also 77 was referred, my lord.
77 should be taken in appealable cases.
Yes, that was there.
Talks about, yes.
That was there. And para 77, for all this, if I read, for all this, it cannot be said that in so and so, it has been laid down as an absolute rule that in the appealable cases, though the examination in chief of a witness is permissible to be produced in the form of affidavit, such affidavit cannot be treated as part of the evidence unless the deponent enters the witness box and confirms the contents of the affidavit, so and so. Now, my lord, I state that this speaks in my favor. Yes. And goes back to the first point which I had made, the second point rather, that an affidavit by itself is not evidence under section 3 or section 2 of the BSA, my lord, and section 3 of the Evidence Act. That being the case, if there is no evidence, there is no question of false evidence being there, my lord. So if there is no question of false evidence, I cannot and I should not, my lord, be prosecuted under 299, my lord. That's all. And of course, my lord, no mens rea exists, my lord. That is also very clear, my lord.
Mens rea noted, intention noted, yes.
Yes,
yes, I think you better give your little notes of submissions because a very fine line.
Very well.
With your first challenge on maintainability with regard to chapter 8A.
Chapter 8.
Rule 10. and whether like it's not false evidence and whether it constitutes evidence at all. Yes.
Yes, Your Lordships, on false evidence, Your Lordships.
Yes.
I want to pass on a copy of the judgment, Your Lordship. This is passed by the Honorable Bombay High Court. Your Lordships, kindly have para 5. This is very similar to the present case, Your Lordships.
Yes.
Para 5, Your Lordships, it reads as under, in all these...
Redaction.
Yes, Your Lordships. In all these matter, a common question of law has arisen.
Yes.
It pertains to Order 18 Rule 4 of the CPC 1908 and some of the issues that arise in relation to affidavits in lieu of examination in chief. Some of these questions and issues are: is it permissible for a court to order the deletion or redaction of any portion of any such affidavit if that part is found to be inadmissible as evidence? If so, at what stage of the proceedings should this be done? Can a party withdraw an evidence affidavit without consequence? Can an evidence affidavit once filed ever be returned, which my learned friend is trying to do in the present case, Your Lordships? What are the consequences if an affidavit is filed and then it is found, perhaps a long time later, that the deponent of that evidence affidavit is either unavailable or cannot be tendered for cross-examination? Where documents are admitted in evidence on the basis of an evidence affidavit and the witness is then not made available or tendered from cross-examination, how those documents are to be treated? These and other allied questions, Your Lordships. Now, para 10, Your Lordships. Para 10 deals with Rasiklal Manikchand, Your Lordships. I had handed over the judgment during my submissions.
Yes.
This particular judgment, Your Lordships, as I had pointed out also, it deals with when the evidence affidavit is filed, when something is sworn before the oath commissioner, it becomes part and parcel of the evidence. Now, the para 10 reads, in Rasiklal Manikchand, the Supreme Court considered a submission by the appellants that the evidence led by the plaintiff was no evidence at all, since the deponents of the evidence affidavits had never entered the witness box to confirm the contents of their evidence affidavits. Both FDC and Ami Trading were cited in support of this submission. The two decisions were considered at length. Rasiklal Manikchand court held that Ami Trading, in agreeing with FDC Limited, did not enunciate an invariable or absolute rule that in every appealable case, a witness or deponent must necessarily reaffirm his evidence affidavit from the witness box and confirm its contents and his signature on it, Your Lordships. Indeed, whether that statement is on oath or affirmation before a notary, judicial officer, or oath commissioner, or anyone else empowered to administer oath, the examination in chief is already on affidavit. There is, the Supreme Court said, no requirement in Order 18 Rule 5 that even in appealable cases, a witness must enter the witness box for production of his affidavit and formally prove his affidavit. The witness is required in the witness box for cross-examination and re-examination, if any, but he or she is not invariably or always required to step into the witness box for examination in chief, Your Lordships. This is exactly the answer to the averments being raised by my learned friend, Your Lordships. In the present case, the requirement of cross-examination does not exist once the evidence affidavit, and in Your Lordships, it must not be ignored that two affidavits have been filed. Two affidavits have been sworn before the oath commissioner, and both have become part and parcel of the evidence affidavit, evidence, Your Lordships. Now, in one of the affidavits, admittedly, and during the entire submissions, Your Lordships,
they're not seeking to withdraw the affidavit.
Your Lordships,
they are going on a premise that, right, we filed two affidavits, but we're not aware of the exact, name of the stamp reporter.
Your Lordships,
earlier on, when we filed it, they said it's Lanong. Second, we found out it's link score. So, there's no question of them being that have tendered the false evidence. And so, I think you're not asking for redaction or withdrawal.
Not at all.
That's what. So, this judgment says the court, if I remember correctly, because I've seen a judgment before, it does not permit, it cannot permit, no evidence if it can be allowed to be withdrawn after it's been affirmed before, an authorized notary or before an oath commissioner.
Your Lordships,
Yes.
in that regard, Your Lordships, the show cause reply was filed earlier to the present evidence affidavit. Now, had the present application been not filed before this honourable court, my learned friend would never have come with clean hands before this honourable court that earlier they had made an incorrect statement, which they have admitted. The entire submissions made by my learned friend, it transpires that they are making admission that there is an error. There is an apparent error.
Yes.
They have tried, and now they are trying to correct the mistake by saying that now they are seeking to withdraw the previous affidavit. With their submissions, Your Lordships, it clearly transpires that they are now requesting this honourable court to withdraw the previous affidavit, the statement which they had made in the previous affidavit. Now they are saying that the statement which they have made in the present evidence affidavit is the correct, and the earlier one is incorrect. So it is nothing, it amounts to the withdrawal of the previous statement, Your Lordships.
Okay.
So therefore, and also, Your Lordships, in my humble submission, what Rasik Lal Manikchand also makes it clear that the statement, once they sworn it before the oath commissioner, that becomes the affidavit. And that,
that's the bottom line. Like, once the court has looked at that, once affirmed, so it cannot be, in a way diluted.
yes, Your
So we
Lordships,
have to look at the contents as it is.
Your Lordships, in my
Because
humble
it's
submission.
It's affirmed now. Whether the question will come to witness box and proving his signature, that's secondary. But the fact remains an affirmation and evidence after it's been filed. So
Yes,
that's the only thing.
yes, Your
So we have
Lordships.
to look at that from that point of view and what the contents and whether that constitutes false evidence or
Your Lordships, in my humble
evidence at all.
submission, it is not in dispute that one of the statements made in one of the affidavits is not correct.
Yes.
It is not in dispute. They have also admitted it. They have admitted in their reply. They have made the arguments also before this honourable court that there is an error. So that is not in dispute. So once the statement is made before the oath commissioner in the form of an affidavit, it amounts to perjury if the evidence is false, if the statement made by them is incorrect.
Okay,
that
noted.
is all what I am saying is your Lordships, that the evidence which they have led, the affidavit which they have filed, the statement which they have made is incorrect, and that amounts to false evidence, Your Lordships. In fact, Your Lordships, just one last submission, Your Lordships, in that regard,
enough time, yes.
Your Lordships, section 227 of BNS 2023,
Yes.
that deals with giving false evidence.
Yes.
Section 227, BNS 2023.
(227).
Yes.
Giving false evidence.
Please, 227 is the definition and 229 deals with the punishment, Your Lordships. 227, giving false evidence. Whoever, being legally bound by an oath or by an express provision of law to state the truth, or being bound by law to make a declaration upon any subject, makes any statement which is false and which he either knows or believes to be false or does not believe to be true, is said to give false evidence.
So that's his main argument.
That's exactly my point. Yes, Your Lordships, this is exactly what has happened in the present case. They agree that the statement they have made in one of the affidavits is incorrect and it is false. So
Okay.
it amounts to
You
a
pass
false
orders,
evidence.
You just give your note submit because it's
Please,
better
please,
fine.
Your Lordship.
Yes. But Mr. Jindal, you take, otherwise this matter is going to be long drawn. I mean, if it's lingered long enough, since 23, now in 25.
My lord, we are anxious to get this matter disposed as quickly as possible. Our witness is on standby, my lord, if lordship.
Yes.
Obliged. Great.
Deeply obliged, Your Lordships.
Item number 8.
Yes.
Wait, please, Your Lordship.
Lords, the matter of Ali Akbar.
Yes.
Lordship, I filed an adjournment application, Your Lordship.
Yes.
I am ready, my lords. I am here. But I
When do
will.
you want it?
Lordship, next week, Your Lordship.
Next week?
Lordship.
I have it, my lords. Then
We
after.
have long holidays, so next
Yes.
week will not be a very
I have it, my lords. After 3 weeks, anyways, my lords, they are not serious.
urgent trip for reasons stated therein. Yes. Right.
Item number 9.
Yes.
May please, Lordship.
Yes. Where's
Lordship.
Actor General?
Lordship, he's out station, Lordship.
We can see that. What about instructions?
Lordship, no, sorry, just that we have filed the affidavit, Lordship. And
When do you file affidavit?
Lordship, we have filed on.
What does it say, Mr. Pasathiya?
They say that there's no vacancy, Your Lordship.
They made a categorical statement.
Yes, Your Lordship.
That's an affidavit filed on 1612.
Oh.
And you're working against vacant posts, correct?
Yes, Your Lordship. They have to come instructions on that point, Your Lordship.
Yes, let them come. The affidavits are present today. Let's up to 1 week. Let's up to 2 weeks, yes. For instructions, yes.
Thank you, Vice.
Yes, we file affidavit.
No, Your Lordship. Appeal is pending,
Then?
Your Lordship, before division bench.
Would issue contempt. When was this matter filed?
It's filed last year. Last year.
How many opportunities been given for affidavit? Have you done anything in compliance with orders of this court?
My lord?
Have you complied with orders of this
No,
court?
nothing has been done,
At
my
all?
lord. My lord. They have preferred an appeal, my lord.
What were the directions? Is appeals is pending?
My lord, they have preferred an appeal recently, my
What
lord.
was the stage of the appeal?
My lord, delay has been condoned, my lord. It is fixed on 16th of April.
Then we'll have it up to 3 weeks. Yes, up to 3 weeks. As an appeal against the order stated to be violated has been preferred by the respondents. Yes. 10, 11, 12.
My lord.
Yes, I-13.
13.
Please, Lordship.
Yes.
This matter can be posted for hearing, Lordship. The rejoinders are on board, Lordship. We've already filed.
Submitted. Please complete this matter by hearing.
Subject to your Lordship's convenience next week or 1 week, Lordship.
Yes. Convenience of court master.
14.
You're all that, sir.
Please, Lordship. This matter, the state have filed the affidavit, Lordship. I need to file the rejoinder because they are not allowing.
Why you refuse to sign the papers?
No, it is because there I was retired as a assistant, sectional assistant. Now they are going to give me the pensioner benefit only from the post of peon. I have retired as a
You
sectional
were
assistant.
already promoted to that post.
I have promoted by the departmental commission. It is there.
You qualified the joinder.
Yes, sir.
Piece of case for now 2 weeks time for the joinder.
Lordship.
Yes, sir, after also.
Much blessed, Lordship.
Right.
15.
My lord, 15 and 16, my lord. I had received the instruction which was not complete and effective, my lord. So
Yes?
I had received the instructions, my lord. It was not complete and effective, my lord. So therefore I am seeking 3 weeks time, my lord.
Who's the petitioner?
Mr. P.K. Bora, I have informed him.
Yes, Mr. Arguru Peace was allowed for 2 weeks time to obtain specific instructions to file affidavit.
16 also.
16.
Tip over.
17.
Lordship, I pray for some more time.
Yes?
I pray for some more time.
Where's Mr. P.T. Sangma? How many times have you prayed for
This is the
affidavit?
fourth.
Fourth?
Most likely, my lords.
What's the matter about? Any urgency?
Only one short submission, Lordship. The petitioner has come against the inquiry report.
Right.
Now, pursuant to the inquiry, a final order has been passed, which has not been challenged. So I have
Oh.
put that in my affidavit. Perhaps he has to.
Mr. S. Dev for response number 8 has submitted that the writ petition has been filed against
An inquiry report.
There are
inquiry
two.
report.
Dated 7th October 2024.
Dated
7th October 2024.
My lords, there's a problem that there are two inquiry reports and they're contradictory.
Wonderful.
So his prayer in the writ petition is to set aside the inquiry of 7th October. Now, pursuant to that report,
It's set aside.
to set aside that inquiry.
It's been set aside now.
No.
No, that's the
Inquiry, after the inquiry, it appears from your lordship is pleased to see my affidavit. Just the last page. Filed by respondent 8, page 26, lordship.
Yes.
Lordship will see, in pursuance to the letter dated 5th November 24 received from so and so, and in accordance with the report dated 7th October, it is hereby informed that so and so. Now, Lordship will see the second paragraph. The review of Srimati so and so, which is myself, Lordship, as fourth teacher, was approved by the order dated 2017. While cancelling the approval dated 2021-1-2017.
See, Mr. P.T. Sangma.
Your Lordship.
Cause of action was in 2017.
Now you've been cancelled also.
In 2017.
This document I don't have before.
I haven't seen it.
Before filing, I don't have this.
When did you file this petition?
This petition was filed on November 2024.
Which exact date?
Exact date is. Lordship, this date.
You filed it on? Yes. See, before you filed, you filed petition before and after your pendency, they have issued this order 22/11/24. You take instructions.
Lordship.
Yes, Mr. P. Sharma submits that as the fresh order dated 22/11/2024 has been passed by the district mission coordinator. After the petition has been filed, he prays him allowed to obtain instructions. Yes,
Lordship. Much blessed, Lordship.
18.
Is that my lord?
This is that application we
We
have.
won't have it today. We'll have it tomorrow because
Tomorrow, my lord.
Yes.
Come on Friday, Lordship.
Let it do tomorrow.
Friday,
My lord. Let it
Friday,
do
Lordship.
tomorrow.
Because I'm not keeping that well. So having fever. So anyway. So
Requesting for Friday, Lordship. If
Thursday is holiday.
Thursday is a holiday.
Thursday is holiday.
Wednesday is holiday. We'll have
Wednesday is tomorrow.
Wednesday is tomorrow.
Oh, tomorrow.
Today is Tuesday.
Today's Tuesday, Lordship.
On Friday we'll have it.
Friday,
My
Lordship.
lord, only thing, my lord, Friday, my lord, no adjournments will be done.
No adjournment. Yes.
Lordship
Ready,
is not-
Lordship. Obliged.
19.
That's not the interim orders continue to next day. Yes. Yes.
This is that dispute between two villages. Now, Lordship has granted me a stay, which is still today. They are yet to file their.
Respondent number 6, private respondent. I'm just on behalf of Miss P.S. Nongri. She's on next in courtroom 1. Just time for us
You're for
also.
1, 2, 5 and 7.
I'm for 6 also.
Then Mr. C.T. Sharma for 1, 5 and 7 as Marpan for 6. Pray for further 2 weeks time to file affidavits. Interim order shall continue the next date.
Lordship.
20.
Yes.
Refer that application form.
My lord, if I may submit, Lordship, this case pertains to Rajabala School, my lord. And my lord, there is another case, if Lordship may kindly recollect. The case is WPC 320/2024.
3?
Jombi Rule 320, my lord,
Yep.
2024. So, my lord, the petition name is Jombi Rule Islam. So, my lord, in that case, if Lordship may kindly recollect, there is an inquiry, my lord, in the entire Rajabala School. So on the last occasion, my lord, I have apprised the court that inquiry has been completed. We are yet to receive the inquiry report. So I have just taken instruction. The inquiry has reached the directorate, my lord. We will be passing order. And my lord, that inquiry will certainly cover this case also because this is also Rajabala School, my managing committee issue. So, and that case is coming on Friday, my lord.
This matter pertains to.
This on Friday.
My lord, on Friday. Because the inquiry will come.
I find this case highly confusing.
It will have a bearing, my lord. We have gone through the entire case, my lord. It will have a bearing. We have seen the inquiry report.
Is there, my lord, in that other writ petition, we have come before the normal court for, my lord, inaction on the part of the respondent, despite there being numerous complaints.
And allegations against SMC.
We'll have it with on Friday. Just with together 320. No, just list on Friday, yes, in the order column. Yes. Yes, Mr. Hari,
Please,
instructions.
Lordship, the instruction is that, Lordship, in Jawai there is some vacancy, is there, Lordship?
Where's the Shulai?
My lord, he is
There's,
on legs, my lord. But my lord, the petitioner has stated that he has recently come from Jowai, my lord. He was refusing at that time, my lord. At the initial stage, my lord, when we were trying to accommodate him.
In Jowai?
He has come from Jowai before attending the East Khasi Hills area, my lord. So we just
Let him
by
go back to
subsequent-
Jowai then.
That was the reason why, my lord,
Let him
the
go to
entire
Jowai.
reshuffling was done again, my lord.
Then we just say that Mr. Jidakha submits that on reliable information, a post in Jowai is present.
My lord, we have to examine that, my lord. Our instruction is full.
Only to this submission, please will have to examine the same list after 1 week. You examine already, you post them Jowai.
My lord.
Consider Bagmarais.
22.
Please, Your Lordship. Lordship, this is a pension matter, Malo.
All represented.
Lordship, I am appearing for private respondent, my lord.
Number?
Private respondent number
8, my lord.
8. Here, my lord.
Yes, so Mr. P. Sharma has entered appearance today on behalf of the respondent by such notice complete or respondents. Yes, what do you want?
Yes, Lordship. Here, this same subject matter. This petition is still pending before the judge of the District Council Court. The order which my
File affidavit, yes.
Yes, it is there.
If was not file affidavit, you'll file affidavit? No.
Not yet, Your Lordship. For respondent 7.
Yes, other respondents have submitted prayer. This order 2 weeks. File it. Bring that on.
Yes, yeah, I have told her. I'll file it, Lordship.
Yes.
Hello. Much less, Lordship.
Lordship, this is promotion to the post of assistant headmaster. Your Lordship, we need some time to file affidavit. We have not received instructions.
No private respondents.
Your Lordship, we have taken steps on.
Yeah, there is one private respondent. One.
Sanjay Rava.
Yes, Sanjay Rava, the last one.
Reservation.
Sorry, Your Lordship.
Reservation matter.
Not reservation, Your Lordship.
Promotion, Your Lordship.
Promotion.
Promotion. Yes, sir.
Oh, the 2 private respondents, 4 and 5.
4 and 5, 2 private respondents.
4 and 5, Your Lordship.
ED card that it is in behalf of 4 and 5. Stop. Next one, MSTIE, BEG. Please allow further 2 weeks time to file affidavit.
Yes, Your Lordship.
There is allowed list up to 2 weeks for affidavit by state respondents for appeal and for service report on respondents 4 and 5.
5. Hi, Your Lordship.
24.
May it please Your Lordship. Your Lordship, I pray that the matter may come up at the end of the board, Your Lordship. The learned DSGI has some important submissions to make.
Lordship, entering appearance also for respondent number 2.
Number?
Number 2, Lordship.
GM. You've examined what
Yes,
they produce?
yes, yes.
What is your prognosis?
Yes, Lordship. They have filed their affidavit also. By way of affidavit, they have brought all the documents. So our documents start.
When they file affidavit? Today?
Today, today they
We'll have it on Friday then.
We have received it today. And
Because it's in the court copy. Mr. Nongrang, today on behalf of respondent number 2, such service complete on all the respondents.
but stay may be considered, Lordship.
Yeah, you complete all respondents. Stop. You are not filing affidavit.
We'll be filing affidavit.
But then what about interim, the consideration of interim prayer?
If I may submit, my lord, the institute has extended their contract till the 31st of March. If this matter comes up sometimes.
31st of March is over.
No, Lordship, not only 31st March or until further order. 31st March or until further order.
They will have it on Friday.
So, Lordship, stay may be considered, Lordship. Actually,
it's on Friday, but then you're still continuing, so you don't need a stay.
Lordship,
Yes.
work order, they may issue the work order.
No, you don't need a stay because you're continuing for others. Matter for the court. On the prayer of N. Mozika. On the prayer of M.S.R. M. Richang.
So, if work order is issued, then we are the agreed party, and the
Nothing can be corrected. Don't worry. If it's, but from prima facie, I don't think you have a very compelling case for interim orders. That's just tentative view of the court. But you can convince the court on Friday.
We have, Lordship.
Yes.
We have, Lordship.
Friday, yes, on Friday.
Lordship, it may be hard. I may be given some one chance to hear. I have some
File
points.
rejoinder?
No, not rejoinder, Lordship. I
Then you
have
will
received
hear
the
you on
documents.
Friday.
Yes, Lordship. But it is like they are taking time. But we are the
on Friday.
agreed party.
It is made clear that the interim matter will be considered finally on Friday.
So,
Right?
25.
Friday.
May please your lodge.
Where is the short affidavit?
Lordship, I have to pay for some more time. Lordship, just a week's time to find my affidavit.
What interim prayer praying for?
So that was with relation to extension of the bank guarantee. We've already extended it. So to that extent, the miscases have become infructuous.
When are you going to file affidavit?
Lordship, if Lordship you can grant me 2 weeks time, Lordship. We've received instructions, Lordship, and voluminous documents, Lordship, but I tried to get it done by this weekend, but then there were some problems where some of the documents were not present in the file, Lordship.
It cannot submit due to unavoidable reasons. The affidavit cannot be filed. Like Mr. SN has also submitted that at present the petition already renewed the bank guarantee. Yes. Just after
2 weeks, no?
2 weeks, yes. For affidavit, yes.
Obliged.
26.
May it please Your Lordship. Your Lordship, by Your Lordship's last order, Your Lordship had directed us to find out whether the Meghalaya State Counselling Authority was in place at the time of the admission of the students for 23-24. You see, this Meghalaya State Counselling Authority has come into place only on 11th December 2024.
And when were the admissions done?
The admission started in November, Your Lordship, and the last date was in November 23.
For admissions?
Sorry, it was on November 24, Your Lordship.
And when was the committee constituted?
It was only in December 2024, Your Lordship. So for
After
the batch
admissions
of...
were over?
Yes, Your Lordship.
There's no question of retrospectively giving
For the batch of 24-25, Your Lordship, they have undergone that counselling, Your Lordship. But for this 23-24...
23 batches, no question of post facto
Your
counselling.
Lordship, there is nothing to say in that there is going to have retrospective effect for the students of 23-24, Your Lordship.
Yes, Mr.
Now, Lordship, what
Lordship,
happened
this
is,
the...
from the record, is very clear.
File an affidavit.
Okay,
File within 1 week.
Yeah, I'll be filing my affidavit.
Yes, MST Yangi, P. Then EAG, assisted by so and so, submits that. What is that called? The committee?
Meghalaya State Counselling Authority.
Yes, the Meghalaya State Counselling Authority
For medical education.
Only on November 2024.
No, 11 December 2024.
Whereas admissions to the 23-24 session were completed on
November, Your Lordship.
November stuff. He praised after doing the same by way of affidavit. Yes. Just after 1 week. Expected next day after you be on board. Yes.
Hearing 33.
Must rest, Lordship.
Yes. Yes, what?
I appear for the plaintiff who is the respondent here. I'm told that Your Lordships, I'm ready for the hearing, but subject to Your Lordships' convenience.
Because I'm not keeping too well. Yes, last night's only thing.
After the
he informed
after
me.
the break, Lordship. Come after 1 week.
If he is not well, then we can do it after BU vacation.
Yes.
Hmm.
Because
Mr.
Kumar is a great BU exponent, so he has to do after BU. You take the date, Mr. Kumar.
Yes, ma'am. We'll give it, we'll check the diary. We'll do it in
last
May.
time actually you were ready, but you were not here.
Yes, ma'am.
Yes.
Yes, ma'am.
Anyway, you take date.
We'll do it in May, first, second week. I'll give you the date.
So just a matter on.
May I?
Take a date from court master for hearing.
Congratulations.
38.
I'll give the date.
Lordship, this is regarding delay in payment of gratuity, Lordship. It came last week, Lordship.
Yes. We'll have it on. We'll have it on the 16th.
16 years.
Obliged.
40.
May it please, Your Lordship. Your Lordship, pray for accommodation in this matter, Lordship.
Yes. Have it yes after. Not 14th. 14th is holiday. What do you mean? Before that?
After that.
You just give a date, yes.
Highly obliged, Lordship.